almost at the finish line with the Ordot consent decree, District Court Chief Judge Francis Tydingco Gatewood addressed a letter submitted by the Guam Solid Waste Authority Board. In that letter, three main issues were discussed. First, the issue of legal services for the board. According to GBB David Manning, it is in the works as an RFP has been issued and a pre-proposal meeting was held with 4 interested firms. Manning says the deadline for submission for bids is on July 17th. The second issue has to do with the board's request to immediately solicit for a general manager and a chief financial officer. While the timeline has been set for January through December 2015 to address the hiring and training for these positions, Board Vice Chairman John Denight argued why wait till next year when it can be done now while the receiver is on island so that the maximum amount of time could be used to learn from the receiver. GBB, however, disagreed, responding, why have a duplication of services when the GM and CFO would not be doing anything and be getting paid? While Judge Tydingco Gatewood stated the board may very well take over sooner than later, the federal receiver stated the timeline originally provided may be extended rather than expedited, which the government's legal counsel, Roland Mantanotnya, found baffling.
We still have a problem understanding why the receiver needs to keep control of that zone or all of GSWA just to make sure that it completes the Ordot closure, which should be done according to our field trip to Ordot on December 2015 and subsequent road projects.
It is this reason that Mantanotnya says the government supports an earlier transition rather than a later one. Meanwhile, Judge Gatewood made it clear that when the court feels the board is ready to take over, they will. She added that time, priority, and funding is what it all boils down to. Funding that GBB says is the reason for the delay, as required management staff and contract employee transition exceeds the receiver's operational costs, and additional costs should be deferred as long as possible. Denight, however, disagrees.
Probably the only thing I disagreed with is the receiver saying that it'll be cheaper, it's cheaper under the receivership than not. But when they listed the cost of the receivership, they showed it as $600,000, and actually it's about $2 million. So
that is an issue that is, the reasons for those are in dispute right now, and I prefer not to comment in regards to that. And any kind of expenditures of money is more of a policy decision that needs to be addressed by my clients rather than myself.
As for the third issue, GSWA is seeking greater involvement and real oversight in operations such as with the Liaison landfill, transfer stations, and residential collections. Denight argued the receiver's role should be relegated to overseeing the closure of Ordot Dump.
All we're trying to do here is save the government possible.
However, Manning says without full control, they cannot guarantee they will be able to achieve all the requirements of the consent decree. Meanwhile, during today's hearing, the chief judge strongly suggested that there not be any further antagonism by Attorney Mantanotnya and the GSWA board toward the federal receiver. Judge Gatewood saying there needs to be more professionalism and civility between all parties. Reporting for Guam's News Network, I'm Jolene Toviz.